Alrighty. Thank you, everybody, for being here. Thank you for registering for today's workshop on understanding the role of discovery in the legal process. Bethany and I are not family law experts, but luckily we know some. And today's workshop is the result of our commitment to vetting and building a partnership with one to help you navigate this particularly complex aspect of divorce litigation. And we promise that you're going to be in amazing hands during this session.
Alexis is as passionate about discovery as we are about divorce, actually. So I'm pleased to welcome her today. She is an associate attorney at Turnbull, Nicholson, and Sanders, PA, where she focuses her practice on family law. A New Jersey native who now calls Maryland home, Alexis Holliday brings a wealth of experience from serving as a judicial law clerk in Baltimore County to advanced training through the American Academy of Matrimonial Lawyers. Named in 2025 as Super Lawyers Rising Star, she's not only a skilled advocate in the courtroom, but also an active leader in the legal community. I've personally had the pleasure of knowing Alexis for many, many years, and I can tell you she always brings equal amounts of warmth, tenacity, and excellence to everything she does.
And we're so grateful to Alexis. Thank you again for being here. And we ask that everybody that's participating to please mute your phone to limit background noise during this presentation. You can ask questions as they come up using the chat function, and we'll either pose the question to Alexis if it pertains to what she's discussing at the time, or during the Q&A portion at the end. And if you have any other questions that we are unable to answer during our time together, we will work with Alexis to provide answers via email, and then we'll include them when we send the recording to everybody.
So without any further delay, we are pleased to introduce and welcome Alexis Holliday.
Thank you, ladies, for having me, and welcome everybody, either who are present today or who are watching the recording afterwards. I hope this provides some valuable insight regarding discovery, because that is a very complex process, and it seems really overwhelming. So just as Bethany and Hillary have noted, I have over 5 years of experience, and I also have 40-hour mediation training, and I'm also best interest certified to represent children going through custody disputes. I am barred in Maryland, and so if anybody has any state-specific questions, I'm probably not able to answer those questions today, but I hope I can provide some background regarding what you're going through. So just so that everybody is aware, all of my discussions are subject to the recommendations of your own attorneys if you are represented, and subject to the laws of your state. And all of these are based on my experience navigating this field. This webinar is not legal advice, and they are state specific. Any attendee of this webinar, either today or watching the recording, isn't a client of the firm that I work for. So let's talk about discovery's role a little bit. So discovery supports settlement and trial strategy. Discovery also provides financial transparency, and discovery also allows informed decision making. I think the Sincerely Divorced group really hits home about empowerment going through this experience, and that's what discovery does. So this is generally what on the screen, how a case moves through the court system. And this could be either if you settle your case ahead of time, or during litigation, or throughout litigation. Today, we're really going to be touching on the discovery process, which is one part of many of litigation. And this can also happen before litigation starts. So really, what is discovery? Discovery is an exchange of important information from the other party to prepare for settlement or trial. When does discovery happen? As I noted, it could be an informal exchange of documentation or information in an effort to resolve your divorce matter, but it also could happen after the filing of a complaint, typically within the first month, but it's really based on a scheduling order that's provided by the court. You should always be informed of all assets, liabilities, and income before entering into a settlement or proceeding to trial. A lot of times people will ask, well, what should I provide in discovery? Or what is my spouse or partner supposed to provide in discovery to me? And really, it's what kind of information are you allowed to ask for? And when going through divorce, especially when children are involved, the scope is very, very wide. The net is wide, and it doesn't matter if a document or an answer to discovery isn't favorable to you. Sometimes that happens and we just deal with it. And there's ways that attorneys can make that more positive than negative. And it also doesn't matter if the discovery is otherwise inadmissible. There are 4 types of discovery: interrogatories, requests for production of documents, requests for admissions, and depositions. Interrogatories are just a formal set of questions requiring answers to be served and signed under oath. These are particularly important because it really gives a general outline of what the other side's position is and their reasons for that. It also provides written answers regarding what kind of money someone earns if you're looking at child support or an alimony claim. It looks at when you're dealing with custody, it looks at why someone's asking for a specific type of custody. So it's really important that this happens because you don't want to be blindsided in the process if you go to trial or when you're trying to go to settlement and trying to figure out where your positions lie and where you can meet in the middle or not at all. So your answers to interrogatories are written with trial strategy in mind. Some attorneys look at them and edit them. That's what I typically do. I look at them and say, okay, well, my client wants this goal as part of their divorce. And how do I get that when they have to answer these interrogatories under oath? They must be truthful, because if they're not, and they're not consistent with what testimony is presented at trial, then their credibility can be impeached, and that may negatively impact the client. Request for production of documents is also a formal request for copies of specific papers. Interrogatories are limited to about 30, at least in the state that I work in. But requests for production of documents aren't limited at this time in Maryland. It may be different in the state that you reside in, but it's really asking for documentation to support what income someone makes, like bank statements, pay stubs, W-2 statements. Text messages is a big one, and I've seen that a lot lately. Medical records could be a big one, depending on the claims of a case. This happens a lot, but I get a lot of clients that ask, well, medical records, they're protected by HIPAA, but in a divorce case, that doesn't apply because you don't have a medical privilege with a doctor that's not a mental health professional. This also can include requests regarding business records, and that may be important because a business may be paying for expenses on behalf of a party that could be considered income for purposes of child support, and also what the value of a business is if you're divorcing someone, because you may have an interest in that property depending on when it was acquired and what the laws of your state are. For a request for production of documents, there's an ongoing obligation to supplement those documents, because as litigation continues and as settlement discussions continue, it's important to have up-to-date information. For requests for production of documents, it's not typically sufficient to object because the other side has the information. It's just easier sometimes to provide the information that's asked for, because sometimes we don't want to make a mountain out of a molehill. We don't want to draw attention to certain things by refusing to provide those documents. I try to have my office, whether it's me or my paralegal, redact social security numbers and account numbers, except for like the last 4 digits, because these documents are being typically sent through email or Dropbox or things like that. And we want to protect our clients' sensitive information. And that's one of the ways to do it. But not every attorney does it, and it's not always required. There's trial strategy and settlement strategy in mind. Do we want to provide the other side with more documentation that they know what to do with? Or do we want to draw attention to certain documentation that we don't want to give because it may not be favorable to your case? I try to give as much information as possible outright because I know that that helps promote settlement, which is more cost effective in the long run. Requests for admissions are a little less common than interrogatories and requests for production of documents. They're typically yes or no questions that you have to admit or deny under oath. This is like, you consumed alcohol more than 1 time in 2023, and you're going to admit or deny that. And then it'll go up in an amount. And this is really trying to get to what are the actual facts of the case and what can I narrow for the court. Depositions happen a lot as well. So depositions can be in person where someone is, they're sworn in under oath, and then they're providing answers to an opposing party's attorney. Usually it's in a lawyer's conference room with a court reporter. They're typically limited in time depending on the case and the state, and then they can be used in court if the testimony is not consistent. This helps the other side or the other party figure out what does the other person know regarding certain questions. There are costs involved with third party, expert witness, or business depositions, like the attorney's preparation, the attorney's attendance, the court reporter, the cost of transcripts. So I try a lot to limit in my practice depositions until after I get answers to interrogatories and responses to requests for production of documents, because this is less cost effective unless I absolutely need it, because sometimes it is necessary. There's also depositions for documents. So this is sometimes known as a subpoena ducis tecum. This is a request for certified documents from a specific business entity. So I sometimes will send it to PNC Bank or Bank of America because I want certified documents that show all of the accounts of one person. You can do this for many reasons. The opposing party won't provide all the documents to determine if there are any undisclosed accounts. Sometimes it's just easier and quicker and more cost effective to obtain the documents directly from the business source, like a bank. But we do this a lot of times because they are authenticated for trial purposes, which helps overcome a potential objection. Sometimes there's a small fee. Other entities charge a larger fee for those records, but sometimes it's difficult to get some of those records. I cannot tell you how many times I have not been able to get records from Facebook or Instagram. Those are some bigger companies. And then there's sometimes entities that I want to obtain records from, but at least in my state, you cannot cross state lines if an entity is registered in a state that's not my own, unless I want to file in that state, and that just becomes more costly. So there are decisions that need to be made as to what documents we want to seek, but at least it provides a peace of mind for clients as to what accounts actually exist at this time or have existed, because sometimes we need to trace down where the money went. What to expect from your attorney regarding discovery. Each attorney is different. They all have their own strategy and methodology. This is something that you might want to consider asking in a consultation as to what their style is, what you should expect. I always like when clients or potential clients ask these questions because it sets good boundaries. It also sets the tone as to what you should expect, how often you should receive correspondence from their attorney regarding discovery, and what guidelines you can expect. Some attorneys will tell you exactly what documents you need to provide. I like to take a request for production of documents and synthesize it into a list of 20 sets of documents that I need from clients, because I think that helps limit the overwhelming feeling for clients, and then they can just check them off as they collect them. Similarly, as I think I previously stated, some attorneys will edit your answers to interrogatories. Not all of them will. And again, that's a conversation for an attorney when you're looking to hire one. How to provide discovery for your attorney. The biggest thing is don't leave it until the last minute. Attorneys have many different clients and also trial schedules to work around. So we don't want to leave it to the last minute, because some of these discovery requirements are drop dead dates, whereas other ones are a little bit more flexible. But really, this helps because it helps for you and your attorney to work together to figure out what's still left and what still needs to be produced. It also avoids just unnecessary litigation, because someone could file a motion to compel for you to provide that information. Similarly, it's easy if you provide interrogatories in a Microsoft Word document or a Google Doc, something that they can copy and paste into the format that's needed, or an email. And then for documents, it's good if your attorney provides you a Dropbox link or an upload portal. Sometimes they just ask you to email them or drop them off. It's really up to them how they want to do it, but just be sensitive that we're not sending social security numbers through email, because we don't know who's going to be, as much as we try to protect technology, it's just easier and safer for everyone not to send their social security numbers through email. A secure portal is probably easier. And I believe Dropbox has free accounts if you just want to send a Dropbox folder or something like that. When we ask for statements, we're asking for the actual PDF statement, not a screenshot of a balance. And I think that's very important, because sometimes we're looking at what for example, if you have an investment account, we're looking at the specific investments and what's contained in that investment account, not just what the value is. This is an example of the Dropbox link that I send to my clients. It helps my clients send documents securely. It emails me every time documents are uploaded, which helps me understand when things are provided and how I can help work on them efficiently. And then you can also upload more than one document at a time, and that helps with time. So there's a duty typically when producing discovery. If a name's on account, even if it's jointly titled, there's still a duty to produce records. It's really annoying to have to produce these because the other side has them and knows of them, but it does help your attorney prepare, which is more cost effective. Even if you don't have online access to an account, you still have to go to the bank or call the bank and ask for a copy of those records. There's also a duty to hold on to information. So once you know you're entering a potential legal litigation or legal process, you cannot delete evidence. That includes text messages, photos, emails, things of that nature. If that evidence is destroyed, it may be held against you. As an example, I had a client who had a cell phone in which he had text messages with his paramour, and that phone was subsequently destroyed during litigation. So the other side could not obtain those text messages, and that was held against him. And that was something that me and him had to deal with when discussing settlement and when discussing trial strategy. And a tip is to change your text message deletion time to not delete at any time until litigation's complete. Regarding text messages, these have become more and more important in a lot of my custody and other property dispute cases, even if we are not entering litigation, because it helps validate a he said, she said, or helps invalidate a he said, she said, and helps the attorney, meaning me, figure out really what's going on and how the parties are communicating. So sometimes I get screenshots, which are helpful, and sometimes they can be used in court. But the best type of text message to provide to your attorney is a PDF of the text message. And I'll show you an example. So here is a screenshot, just a very basic screenshot. I've redacted the information to keep parties' information out. And so there's no phone number associated with this text message. There's no date and time sent, and part of the text message is cut off. And otherwise you're having a stack of papers, which sometimes happens, to be able to read through a bunch of screenshots. But this doesn't give the full picture of what's being discussed. So this is subject to challenges of authenticity. Parties forget when these text messages are sent, and that's also a challenge that can happen in trial. And someone can say, I didn't send that, because who's to say that that wasn't someone else with the contact name saved as that person? In comparison, this is an example of, even though a bunch of it is redacted, this is an example of a PDF of text messages that I received in discovery. So as an example, there's a bunch of text messages on one page. It's legible. It gives the date and time of the text message that's sent, but it also gives the date and time that the party receiving the message viewed the message, which I think is important, because there may be disputes as to when someone saw something and maybe they did or did not respond timely. It also provides the phone number of the sender, which is very important. As I said, then it is less subject to challenges that a party did or did not send a text message, unless someone had their phone, but that's not very typical. It also provides a complete conversation. I've put on the screen 2 different websites that I've had clients have good success with. The cost is approximately $30. You download it on your computer, you plug in your phone, and then you're able to download the text messages that are asked for. There are different programs for Android users, but this is a lot. I think a lot of people do have iPhones, and so this is very helpful. But if you Google ones for Android, I've also had clients provide text messages through PDF for that kind of phone as well. So discovery's role in custody disputes is really important. We've propounded interrogatories like, what child care do you plan to follow? What individuals do you intend to care for the minor child? What is your typical work schedule? Because someone will say, I have a flexible schedule, and then you get their time cards and it's not very flexible. In terms of requests for production of documents, provide all text messages with the minor child. That'll show if a parent is coaching a child. That'll show their relationship. That'll show if the parent is having any inappropriate discussions regarding the litigation. Those all have impacts on custody, and it avoids surprises when you go to trial, but it also uncovers relevant information when having settlement discussions. Similarly, bank statements are fair game in custody disputes. They determine what a parent's spending their money on. They determine if a parent's neglecting or misusing funds, and they also determine whether a parent's paying for expenses on behalf of a child. I'm not going to go through all of the examples, but one example is mom was having an affair. Mom tells dad she's at the movies with the children. Dad propounds discovery, and mom sends responsive documents and answers to interrogatories. In her answers to interrogatories, she states under oath, I was at the movies with the children. The bank statements reveal There were no charges for the movies at that time. The text messages are provided in discovery with her paramour that she took the children to the paramour's home on that time. This was a true case, and it was found that the statement under oath was untruthful. It was corroborated by multiple sources, and her credibility was impacted because not only did she state it under oath in her answers to interrogatories, but she stated under oath at trial. And she brought the minor children around the paramour, which was just a bad judgment call when the judge was deciding legal custody for the children. Another example, mom claims dad attempted to run her off the road, and the child was in the car with her, and she filed both criminal charges and a protective order against dad. Dad issued subpoenas to the surrounding businesses for their video security footage. The footage revealed that dad's vehicle was never approached mom's vehicle, and the court found at the hearing when that footage was presented that mom's vehicle actually approached dad's vehicle. The protective order and criminal charges were dismissed, and at the custody hearing, mom's false statements, both to the court when she filed both the protective order and the criminal charges, were used against her regarding her credibility and how she misused the court system to gain temporary custody of the minor child. Similarly, discovery has a role in property disputes. What property exists is a big one. What's the fair market value of that property, and do I need an expert to value that property? In Maryland, there's a term called non-marital property, and potentially you need to understand whether or not there's a claim for non-marital property, and whether or not there's a claim of dissipation, which is the intentional misuse of marital assets. Dissipation is dependent on your state, but discovery can help your attorney and yourself whittle down that whether or not that claim is viable for trial or settlement. Again, this avoids surprises, uncovers relevant information, and assesses credibility of the parties. An example, husband propounds discovery, including a question, an interrogatory related to all property sold, and the value received for it. Wife lists she didn't sell any property in her responses and her answers, but husband actually obtained documents from India that wife used an old power of attorney that she had to sell property of husband in his sole name and received cash for it. Actually, in India, you get photographed when you sell property, and her photo was on that documentation. She still disputed the claim. He made a claim that she dissipated marital assets and requested that the value be considered for a monetary award. And ultimately, even though the case settled, that was part of the settlement, was to help make husband whole for that sale of that property. There are some pitfalls for discovery, so there may be incomplete answers or documents, which could delay the process, failure to timely respond or supplement discovery. This is avoided by just making sure that your attorney tells you when they need updated information, and having that kind of communication. Another pitfall is overlooking privilege protections. There aren't many, but there are some, like attorney-client privilege, attorney-client communications, or mental health records, unless the court orders someone to produce their mental health records. If those records are produced, that may permanently waive that privilege. And then the privilege also has to be affirmatively asserted. Like, I assert my privilege with Dr. X, who is my psychiatrist. It's important to communicate to your attorney about who your mental health providers are so that they have that information. Another pitfall of discovery is failure to review discovery provided in response to the propounded discovery. Your attorney should provide you a copy of everything that's produced in discovery. It's helpful for when my clients provide insight to the responses, whether or not they believe something is false or not totally truthful, because that helps develop not only my settlement discussions, but also my questioning at trial. And then I think one of the biggest ones is assuming the opposing party will play fair, whether or not you want to reach a settlement or not. Because sometimes people don't necessarily consciously evade their obligation to just fully disclose everything, but sometimes it is conscious. So my biggest piece of advice is to trust but verify. So accept what someone's saying, but then make sure that that's supported by documentation. Having written answers to interrogatories signed under oath is also a good way to do that. And then just doing due diligence and reviewing documents and making sure that we're not just accepting what someone says. I believe Bethany and Hillary have touched on in both their socials and in other webinars, like forensic accountants. I believe there's one coming up, or retaining a financial advisor if you don't fully understand the financials of someone and want to either double check or understand what assets or income someone has. Discovery can, like I've already touched on, impact negotiation, mediation, and trial because it does give you the power to reach a settlement. When there's informed decision making, anything is possible as long as the other side is obviously willing to agree. But without discovery, you may be agreeing to something without knowing what you're giving up or what you're getting. Examples are an opposing party works for a family-owned business. Subpoena is sent to the family business and the business produces records to the attorney. Without just the discovery, you may not have known that the business pays expenses on the party's behalf, which may be considered for income, for alimony and child support purposes. You also may not understand that a business pays into a 401k that you never knew about, which could be subject to division if that applies in your state. So those are all just very general examples, but they are important to understand versus just, I'm going to keep what I have, that they'll keep what they have, and we'll just walk away, which is a decision to make, but it should be an informed decision. There's ways to encourage financial transparency with your partner if you don't want to enter into litigation. The first thing is to just set the tone. Hey, I know we want to reach an amicable resolution, but let's just exchange a couple of documents and make sure that we're all on the same page, that we can walk away from this knowing what we're walking away from. Similarly, is important, is your agreement based on the principles of your state? Sometimes you may be entitled to more things or more assets or alimony or child support than what you may necessarily be agreeing to. And similarly, like if we reframe from, oh, I need to win, to what's fair, I think that helps encourage financial transparency because there's no winning in divorce. And a lot of times children are involved and we just want to get to the other side and then feel free. When in doubt, seek help. Attorneys are there to not only help you through litigation, but to help you baby step the process because they can provide guidance without your partner even knowing that you are engaging with an attorney, and they can give you a little bit of insight as to what the principles of your state are. And I sometimes do that with my clients when they're going to mediation with just them and their partner. I can help say, well, have you thought about, I don't know, how to divide extracurricular activities? Or have you thought about the division of this retirement account? Have you thought about the tax implications? And while I'm not a tax attorney or an accountant, there are certain things that I can help guide clients with once I know what assets, liabilities, and income exist. So all in all, financial transparency avoids future challenges to any agreement. If there was an exchange of documents, that totally helps the challenge to that agreement. Sometimes it still happens, but that is one of the ways that we see that makes the agreement less likely to be stricken. It also builds trust and credibility, especially if you are going to co-parent with that person, because that shows I'm willing to give you any documentation that you want. You're willing to give me what I want so that we can get out of this amicably and start co-parenting our children. It also limits unnecessary costs. A lot of times costs are driven because one side, the other, or both want to play games, and financial transparency helps limit that. And it can become costly for some parties. Ultimately, you have control of the outcome when there's informed decision making, and discovery is one of the most important roles in that informed decision making. Divorce is emotional, and discovery is more than just a legal step. It helps provide uncertainty to clarity. It provides confidence in the parties to know what to ask for, what's fair. It helps bring peace of mind and reduce the fear of the unknown. And it helps protect your own rights. And it helps ultimately help you make informed choices about your future and happiness. Once again, I want to thank Bethany and Hillary for allowing me to present. And if anybody has any questions, I'd be happy to answer them, as long as they are not fact specific, because I cannot provide legal advice. But otherwise, I will return the floor to Bethany and Hillary.
Thank you, Alexis. We did not see any questions come through in the chat, but we just had somebody ask a question. Can you talk about QDRO?
So quadros are a little bit nuanced. I don't specifically, so if anybody doesn't know, a quadro is a qualified domestic relations order. That happens when someone has agreed to transfer a portion of a retirement account on a tax neutral basis to the other party. That happens when a quadro is submitted to the court and the judge signs it. And those are typically drafted based on the plan requirements of that retirement account. And then that judge will sign it, and then it's served on the plan. Once the plan accepts the quadro, then they will transfer whatever retirement monies, whether that's ordered by the judge or in an agreement, to the receiving party.
Sounds complicated.
I know.
It is, and that's why I don't necessarily draft them, because they're so nuanced depending on the plan. So we typically, when either a judge orders for retirement monies to be transferred, or when it's part of an agreement, we hire specific attorneys to do a flat fee to draft those and to follow through with them.
Are those attorneys that specialize in financial?
They typically specialize in quadro preparation. So a lot of them, at least one that I work with a lot is I believe he was a former CPA, or he still is a CPA, but not necessarily do they have to. It's just someone who has the expertise and have done a lot of them.
Okay. Interesting. Well, a follow-up question to that about the quadro is, can profit sharing be included in discovery?
Yeah, so if someone I believe the question is if someone receives profits from a business or something like that, can you understand that that's happening? And I think the answer is yes. You can certainly ask for all documentation related to profit sharing, and then determine how that's going to be divided during a divorce.
Great.
Thank you.
Well, it looks like those are all the questions. And so again, Alexis, I just want to thank you for your time and your expertise, and for making a very complex topic very manageable to understand. I mean,
Yes.
that is truly a gift, and it is you sharing it with our community, and we look forward to seeing you again on another topic. But it's clear that your passion is for this topic, but more importantly, your passion is for helping people navigate this from a place of strength and empowerment. And for that, we are very grateful for this partnership.
Thank you. I appreciate it. And thank you for having me again.
Okay.
Yeah,
well, we'll see you soon.
Great. Thank you.
Bye,
Thank
Alexis.
you. And we will send everything out via email to everyone that participated.
Oh, okay. Sorry, Wesley. We will make sure if you're still on the call, we'll get this question to Alexis and make sure it's included in our email follow-up. So,
and if anybody else has any other last final questions, feel free to drop them in now and we will, or you can email us too, and
Yeah.
we will get them to Alexis to try to get it to her to answer them.
yeah, and that's just at hello@sincerelydivorced. Okay, Christy, sounds good. This is great. I love that you're asking questions, and we hope that this was helpful.
Yeah, feel free to, if you want to drop it in here now.
Yeah.
Um,
Okay. Yeah.
okay.
Certainly. Add more detail.
Okay. If you, oh. Okay. Okay. All right. We will send this over to Alexis. And like I said, when we email the recording out, which will probably get to you early next week, we will include the answers to these questions. So, well, thank you again for attending this evening's webinar, and we hope that it was helpful to you. And if you have any feedback or, like I said, any other additional questions, feel free to email us, hello@sincerelydivorced.com.
And we so appreciate you being a part of this community. It really means everything to us. So we will make it through this together. So,
all right.
We'll see you soon.
Take care.
Bye.
Bye.